Hi, welcome to Balfour Ma. I'm Tom Ma. Today I'm talking about why doing a will is not estate planning. Now, a lot of people come and say, well, I want to get my will done. It's really important to me, Tom. What's involved? How much does that all cost? And I say to them, well, look, doing a will is a byproduct actually of getting proper advice. And getting proper advice is a byproduct coming from us understanding what your particular circumstances are. And quite often in this modern day and age, not everything is dealt with under your personal estate. You may own your business through a trust, and another form of trust that people aren't aware of is a retirement trust, or more commonly known as superannuation. So that's held on trust, and that's outside of your normal will. And also you might have things like insurances, life or TPD, or total and permanent disability insurances. That again is yours, so to speak, but it's held away from your estate per se, so it's not necessarily dealt with under your will. So the first point that I say to people is, let's understand what you have, what you own, what are the assets and what are your liabilities. But what do you have in your own name versus what do you control? So things in your own name is if you've registered a car, if you own just your home in just your own name, money in the bank, your watch, computers, etc. They are your personal assets and they form part of your estate. Now, if you happen to be in a relationship and you own your house, say with your spouse, quite often you're on the title as joint tenants. If you invest in property and you may own it with other parties, you're tenants in common. But if you own your home, or it could be an investment property or other property, joint tenants, then that's actually outside your personal estate. For under property law, it will go to the survivor of the joint tenants automatically outside your will. So you can't give your interest in your joint property to your spouse or whoever else you want to. You would go to them automatically. Now, just remember, when I say property, just remember that you can have more than just a home being joint property. You could have shares jointly owned. You could own a boat jointly. You could have a bank account that's joint. So joint tenancy is an important aspect to understand how that affects estate planning. The other thing is then coming back to your family trust. The family trust quite often could be used for business ownership. You might use it for investment purposes, owning investment properties or shares. You might have multiple ones. It's not uncommon as well. So the succession arrangements need to be dealt with under the trust deed itself. It's a very prescriptive instrument of law. Now, some lawyers say, oh, well, look, we can deal with that under your will. But for three really important reasons, I'm going to say why you shouldn't do it inside your will. Now, with having a trust, what happens is it's actually controlled by someone known as the appointor and or guardian. In the modern day and age, a well-drafted will doesn't always have a guardian, you'll just have an appointor, but they are the person who has the right to appoint or remove the trustee. So the trustee is sort of the puppet that runs it and administers it and gets the right to determine where the income and capital, the monies go from it. But ultimately, whoever is the appointor is the controller of that trust. And for succession purposes, it's handing that appointor role over to normally your surviving spouse or down to your children. And what I make sure is that they act jointly and unanimously, and you build in a dispute resolution provision in the deed of succession for that family trust. Now, again, as I said, the reason why we don't put it in the will is as follows. Firstly, when you die, your death certificate will take normally several weeks before it becomes available. And then only then when your will is presented and it goes to the Supreme Court probate registry with the death certificate, with the affidavit, and probate is granted, can you administer the will, and that power of appointment of appointor could be dealt with. So if there's a delay in doing that, that would actually be a problem, and you couldn't get to jump into and change over the trustee or appointor and the trustee under your trust. So it's very important to understand that. That could delay things. The second thing is, you don't really want to show that variation to the trust of the appointor power, because later on things like banks and other parties need to sometimes see it. You don't always have to produce the will of the deceased appointor with the trust deed. So it sort of looks not neat or tidy. So I always recommend do trust succession that way. The other aspect is superannuation. It's very important to understand, do you have a self-managed super fund? Do you have retail, wholesale? Now, under those, you need to do what's called a death benefits nomination or a binding death benefits nomination, depending on what type of superannuation fund, and each one is different. So there is no standard form. You must understand which superannuation fund requires what form to be completed. And that binding death benefit nomination, quite often with the retail and the wholesale ones, will only last up to 3 years. And then after 3 years, you've got to go, oh, I've got to renew it and redo it. And normally you need to determine who the beneficiary will be, and that's normally your spouse or a financial dependent, and that's determined under the Superannuation Industry Supervisory Act. Otherwise, there's some tax that will be payable. But you can send it back to your estate under those directions, and it's commonly known as sending it back to your legal personal representative, and that streams that super in there, and you could then, if there is no eligible dependents, then it will go into the balance of your estate, but the tax will be paid on it. Alternately, if there is a dependent there, it could actually stream through if it's well drafted. At this stage, you're probably going, my gosh, now I understand why you're saying that wills aren't standard. This is just the complexity of everyday life, the laws, finance and tax. It's not something we make up, it's something we understand and deal with. So wills and estate planning is not just a simple exercise of preparing that will document. It's actually about understanding what documents, what are your arrangements, what are the legalities, and then making sure that that addresses your wishes, but also ensuring that it is compliant in all aspects. Because the last thing you want to do is think that you've dealt with one thing, but actually it turns out that it was incorrect or invalid, and therefore other parts or maybe your entire estate planning wishes and arrangements fail on that basis. Now, we've only really talked about just getting your wills ready, and there's many other aspects which we can talk about in a separate session to do with enduring powers of attorney, enduring powers of guardianship, or advanced health directives or living wills. These are other things that are very important that, of course, your will won't apply unless you die, but these things will kick into place, so to speak, if you're still alive, but certain events occur that you want to make sure are properly attended to and appointing the right people to look after your interests. So this is something to get you started about understanding that estate planning. It's a lot more than just simply doing a document. It really is about understanding what have you got, what is involved, and how to go about it, making that informed decision to correct estate planning and then the documentation.